wanted to get this meeting started on time. And so I want to open today's meeting, our November 15th meeting on a policy committee meeting. And it is now 3:31 p.m. And so today we're going to be hearing from Chief Simon and looking forward to this presentation. And we also have Kimberly Mooney here with us too to give some public testimony. So welcome, and it's good to see you again. And so Christian, I'll pass it off to you. Did I forget anything, Christian?
No, you didn't.
Great.
Dr. Brooks, may I just say something very quickly?
Yes.
This is National Arts in Education Week. I just wanted to make sure that I said that because I think it's critically important that we recognize that. And then certainly today has started National Hispanic Heritage Month. So I just wanted, it's the teacher in me that has to remind us of these types of things every month. That's all.
I appreciate it. Thank you so much, Commissioner McFadden.
Good afternoon, commissioners. So we're going to present today, and building on the teachers, there's a little bit of background in this presentation on some new regulations from the federal government. So part of this is going to be to go through those. So bear with me a little bit in that, but feel free to take questions at any time. So what we have before you today is updates to policy ACB and regulation ACB-RA, which were initially brought to the committee before I joined you all in last January, and due to the COVID-19 pandemic delay, we've reset and gone back. And it's actually a good opportunity for us because there have been some interesting developments that we've taken advantage of here. And so the goal is to take the sex-based discrimination policy and regulation for employees and third parties and align them with the corresponding policy and regulation for students, which is policy JBB and regulation JBB-RA, which were adopted by the board in April 2019, also address a number of Supreme Court cases and other legal requirements. And I should say that's in part why I'm here, but I'm also, we are doing this work in conjunction with the Equity Office, and the Fair Practices Department rolls up to me, and Jane Ehrenfeld, our new Director of Fair Practices, should be on the line. And she's going to take a laboring oar in this work going forward, but I volunteered to do this today. So the Supreme Court cases, as well as the new Title IX sexual harassment regulations issued by the United States Department of Education. And then to build on our ongoing work on equity, as well as our work to support LGBTQ students, employees, and other stakeholders, which we presented to the board on August 25th. So flipping to the next slide, just as background for the public, the committee members all know well, the board adopted JBB and regulation JBB-RA in April of 2019. And the policy and the regulation confirm that sex-based discrimination includes discrimination based on gender identity, gender expression, sexual orientation, and stereotypical notions of masculinity and femininity. So that's the alignment is important here because we're aligning the policy and regulation for employees with what we've already done or what the board's already done for students. And then the next piece of alignment is, if we can switch the slide, is to Supreme Court cases and other legal developments. There was a significant Supreme Court case a couple months ago called the Bostick case, where the Supreme Court ruled that employment discrimination based on gender identity, including transgender status or sexual orientation, is covered by Title VII, which is the federal law that protects against employment discrimination. Now in Maryland, for a while, that federal law guarantee was part of state law, but this is an important guarantee and clarification of federal law. The other important piece in the development of Maryland law was the recent state law that authorizes use of non-binary gender designations on driver's licenses. And so that's an important piece that we've aligned with the new proposed policy and regulation. Switch to the next slide. And then the other big development, which you'll see the impact of this in the number of pages that we gave to you today, which were a lot, and I'm sorry about that. But the Department of Education has been, for a little bit of time, proposing new regulations for Title IX, which is Title IX of the Education Amendments of 1972. So this is a law that's been around a while, and it requires educational institutions to have a sex discrimination policy and grievance procedures. For a while, it's been settled that sex-based discrimination extends beyond sexual harassment to cover discrimination based on sex, sexual violence, sexual orientation, gender identity. There's actually some interesting, we can go into detail, but some parts of the Bostick decision where some of the Supreme Court justices weren't clear on these pieces, but we've treated it as clear for a while in our interpretation of Title IX. And importantly, Title IX protects students, but it also protects employees. And so that builds off there, and this becomes important later on. So switch to the next slide. Other key regulatory requirements is that we must have a Title IX coordinator, that the Title IX coordinator needs to oversee investigations, and that there are provisions on confidentiality of grievance procedures, which we've all covered for a while. Next slide. So the new regulations that came into play this spring, they were preceded by rescinding all of the prior guidance. And this is significant because there was a long-standing set of guidance documents from the U.S. Department of Education that very clearly set forth standards. And this switched it all up and changed things. So this was a really significant development around what was the definition of sexual harassment and how you investigated it. And I'll go through that, but this is a really big change. And so the U.S. Department of Education's Office for Civil Rights issued proposed regulations. There was a lot of interest, thousands of comments, pros and cons on these regulations, and some concerns about both what these regulations changed. And we can go into more detail, but suffices to say that the final regulations were issued in May of 2020. And there was a big push by a lot of school districts and higher education institutions, because a lot of this is coming out of the college and university level on sexual harassment, and that's been in the papers a lot. There was a push by universities and colleges to delay implementation due to COVID-19 because we've got a lot else going on here, and this is an additional piece. But the Department of Education said, all we're going to give you is until essentially the beginning of the school year, but you have to have these in place. Then there were a number of legal challenges pending. Some of them tried to make the argument that more time was needed for school districts in light of COVID-19. But so far, courts have not imposed any injunctions or stays or anything like that. So that's why we're going forward here. And critically, these apply to sexual harassment complaints filed by students, employees, and other third parties participating in K-12 as well as higher education programs and activities. So let's switch to the next slide. So I'm going to go a little bit into an overview. I'll go relatively quickly here, just so you can see, because we've tried to map onto these regulations, in addition to alignment with JBB, to make sure that we are copacetic and aligned on these new regulations. So these new regulations say that any person may report sexual harassment at the K-12 level, and it makes city schools employees mandatory reporters for these purposes. So just like in child abuse, there's mandatory reporting on child abuse. Now city schools employees are mandatory reporters for sexual harassment as well. And they have some new terms. Instead of talking about a victim and a perpetrator, they talk about a complainant and a respondent. So those you'll see track through all of our grievance policies now. They also say that even if a person who experienced sexual harassment declines to pursue the complaint can still proceed if it's signed by the Title IX coordinator. So what does that mean? It means a student who comes forward and says, I experienced sexual violence from another student in a school facility, but I don't want to pursue my complaint. we still may have a responsibility as a school district for saying it's really important for us to investigate this, even if though the person doesn't want to pursue. We are sort of focused on the complainant and we need to take that sensitively, but there are significant institutional reasons why we need to move forward here. So that's a big point of clarification. It actually is consistent with our current practice, but it's now part of these regulations. So let's go forward to the next slide. So it also changes the definition of sexual harassment. And so it has 3 prongs. The first prong is what's typically called, quote, quid pro quo sexual harassment. And it's if an employee conditions aid or benefit of a service on a participation in unwelcome sexual conduct. To break down the legal words, that's basically if an employee says to another employee, I will hire you for this job if you have a sexual relationship with me. That's what that prong is talking about. The next prong is what we often know as hostile work environment sexual harassment. So this is when there's unwelcome conduct that's so severe, pervasive, and objectively offensive that it effectively denies a person equal access to educational programs or activities. And here's where the big change came, because under Title VII, which is employment discrimination law, it's essentially, you see, severe, persuasive, or objectively offensive. Now it's and. So you have to do all of those things to meet the Title IX definition, where under Title VII and under our prior definition, it was an or. So you had to be severe, persuasive, or. And that can make a difference. And that's what some of the commentators were concerned about, that distinction. But now that's the federal standard. And so long as it's the federal standard, the challenge to a school district is if we didn't comply, we would be at risk of losing our federal funds. Now, that doesn't mean that we can't, as a district, protect more, and our code of conduct, our Title IX laws go further, Title VII protections go further than that, but we just have to be clear that this is the definition for these purposes. And then the other prong is sexual assault, dating violence, domestic violence, and stalking. So that's the definitional piece. Let's go to the next slide. Then the regulations go on at great length, and that's why our regulations have to match this, about we must respond promptly in a manner that's not deliberately indifferent. What does that mean? It means that we must respond in a manner that is not clearly unreasonable in light of the known circumstances. So we have to follow up, we have to investigate, and we have to take action. The other thing that's a big stress of this Department of Education, of this federal government, is treating complainants and respondents equitably. Not jumping to conclusions before we investigate a situation of sexual harassment, and making sure we file the process and determine, don't impose disciplinary consequences until we go through the process, and make sure we're providing support to both parties as the process goes forward. Let's go to the next slide. What they mean by supportive measures is what we used to call interim measures, basically non-disciplinary, non-punitive measures that try to allow both parties to participate while the investigation is going on. So this would be in the student-on-student sexual harassment case. This would be switching a student to another class while the investigation is going on, or providing counseling. And you could extrapolate to the employee context is separating the two employees while that's going on. Next slide. The policy does provide, so it generally provides you can't impose a discipline while the investigation is going on, but you can do an emergency removal if there's a real safety risk that justifies this. And this is actually going to be a challenge for us on the student level, because as you'll see, the timelines for this whole process don't well map onto our state law bullying requirements or our state law discipline requirements. So the discipline and bullying requirements under current state law are much more accelerated than the Title IX process. So we're going to have to do some work in some of these investigations where they could to support our principals or our supervisors to make sure that these processes align. And because it's the federal law, what the feds say is that their law and the regulation trump what happens in state law. So it supersedes state law. Next slide. And then there are there are separate protocols for filing a complaint, for the investigation, and for making the determination. And the person who determines responsibility is not supposed to be the person who investigates the complaint. So they're basically separating those two roles. And the decision maker must provide the final determination of responsibility simultaneously to both parties. So there are all sorts of rules about how the decision has to be set out, which we can go into detail if people want more details on that. Next slide. They also stress that there shouldn't be any bias or conflict of interest from the person investigating. That's a standard piece, but that's now set out. Next slide. And they go into much more detail about what remedies should be. So, and I think this is important, and this was in the policy, but we took an opportunity to spell this out, as you'll see. So remedies should be designed to restore or preserve equal access to educational programs and activities, including disciplinary consequences for respondents. But they also include supportive measures for the complainant and other parties, meaning counseling, meaning potentially all sorts of measures to restore, and then also school-wide and district-wide actions, including training, not just for the people involved, but many investigations point to the need for additional training, additional restorative practices, and even us to take a step back and say, that teaches us something that we need to update our guidance or maybe even our policy itself as it goes forward. Next slide. Then there's a whole appeals process. I won't go into detail here, but basically what we appeal to the CEO or designee, and then from the CEO or designee to the board. So that you'll see as a preview that the appeal process is much more clearly sketched out. Again, this is consistent. A lot of this is consistent, but what the new regulations say is we need to be explicit about this and go into more detail. Next slide. So there's also a set of requirements for when we must dismiss a Title IX complaint. So a Title IX complaint cannot go forward if it doesn't constitute sexual harassment, if it didn't occur in our educational programs or activities, or it didn't occur as part, or didn't occur in the United States, I guess presumably a field trip abroad, which is an interesting shift. And even if we dismiss a complaint, and I think this is important, it can still be addressed under our code of conduct or our discipline processes. So to be very clear that if it doesn't meet the definition under the regulation, our hands aren't tied to move forward and process it. Next slide. There's a strong protection against retaliation, which we already had in our policy, but we took the opportunity, as you'll see, to make even stronger. Next slide. And then there's an express record keeping policy that we have to keep records for 7 years. And so that is important from just what we have to retain as the process goes forward. And we also have to, the requirement is that we post a number of materials on our website and then retain the materials, including training materials. Next slide. So that was a lead up to how did we take our effort to align everything to deal with this whole big new regulation in record speed, right? So we've done this really since this came out in May, and then it became clear that this is now going to go into effect. So we wanted to get this in place, and you'll very much see a draft. So I'm sure there are pieces that we can improve, but we felt it was really important to fulfill our legal obligations to take this opportunity that was already on the books to look at ACB and update ACB to align with JBB to also fix and address the sexual harassment regulations. So let's turn first to policy ACB. So one of the key things we did was to make a clear non-discrimination policy statement that was added at the front of the policy, and make it very clear that we are extending sex-based discrimination to gender identity, sexual orientation, gender expression, and sex-based stereotyping as from the outset. And you'll see this is very similar to what we did in JBB and JBB-RA beforehand. Next slide. We also aligned the definitions, a number of definitions that had already been put in place by JBB. We added into ACB, and actually we tried to, one of the things that we've experienced in policies here and elsewhere is that if you amend one policy and then you amend another policy and each one has a definition, sometimes if you forget to amend all of them, you have definitions that are different. So the thing we're trying here, and it would be interesting to get the committee's feedback, is we just cross-reference to the other regulations. So we're not repeating all those definitions, but we want to say, these are the same, so that we don't get the two policies or the two regulations out of alignment. Would love, and as we get to the end, would love feedback on that, but that was our effort to try to make these regulations move and policies move forward in tandem. Next slide. Then we updated a number of definitions that were in JBB, but we updated them in ACB so that they aligned with the new Title IX regulations. And then we went back, as you'll see, to JBB and changed the definitions there too. And those include sex-based discrimination, sexual harassment, third parties, meaning non-students, non-employees. And then we defined, remember I talked before about complainants and respondents. So we defined those very clearly. And we can go to those definitions when we walk through the policy if you'd like. Next slide. We also, consistent with JBB, we wanted to take the really strong language in JBB about supporting employees' gender identity and gender expression and put in sections on use of pronouns and names, meaning that the right of our employees, like our students, to be referred to by names and pronouns consistent with their gender identity. Also, dress codes and making sure that our dress codes and the right to dress is consistent with gender identity. Access to gender segregated facilities, meaning bathrooms and the like. Protocols for altering and adjusting personnel records so they're consistent with gender identity, and also for requesting a name or a gender change. So those pieces, they're slight tweaks because of the difference between an employee and a student, but there's a consistent walkthrough and crosswalk between JBB and ACB. Next slide, please. We also, you'll see in the policy ACB and ACB-RA, we align the reporting and investigation process for sex-based discrimination. We aligned ACB and ACB-RA with JBB and JBB-RA. And then, as you'll see, there were some conforming changes so that they both work together, and because we want to keep them as closely aligned as possible. Next slide. Then we, in ACB, put in place a separate section specifically to address sexual harassment, which we defined as a subset of sex-based discrimination. Incorporated, so those processors are set out in great detail in JBB, sorry, it should say JBB-RA. That's a typo. So JBB-RA, not JBA-RA. And then we incorporated them into ACB-RA. There's a lot of initials going here. We clarified that an employee can either pursue the workplace sex-based discrimination proceedings or the Title IX grievance procedures, and depending on which they'd like to pursue. And we incorporated them all by reference to try to, again, so we're not doing 50 pages of policies, we're only doing 20 pages of policy. Next slide. And then this is a list of stakeholders that we'll go back to, but we did go to them initially when we talked about in last January, so we need to go back to them as part of this process. And that's part of the work that's upgoing. So that's a lot to digest, and I'm happy to walk through the individual policies and point out some of these changes, but I wanted to stop there to open it up for comments.
Great. Thank you so much, Chief Sivan, on the work, and definitely going through and reading. All of them was a little bit, I was like, oh, these are concentrated elements. And so what we'll do first is hear from some of our commissioners, and then we'll invite Kimberly Mooney to give some commentary after we've had some discussion. Other commissioners, do we have any questions regarding these changes in the policy?
Sure. Okay.
Yep.
So a couple of questions. One on ACB in the regulations on page 1 of 7, Roman numeral 2, reporting sex-based discrimination against the employer, and then letter B. And I'm guessing this is throughout. Letter B says currently an employer or third party who files a sex-based discrimination complaint shall utilize the sex discrimination reporting form. My belief is that this policy, and this is actually a great policy, Chief Sivan, to demonstrate the evolution of policy over time. You know, we adopted it, we figured out what was working, and we're reevaluating it. Requiring the complaint shall utilize the sex discrimination reporting form is an out for an accountability person. Oh, they just told me about it. They didn't use the form, so I didn't follow up. So within that, I understand why it's written that way, but perhaps adding if the complaint is not on a sex discrimination reporting form, it is the responsibility of the person hearing to send them that way or direct them to that.
And there's actually more. So if you look then right below that,
yes.
So at C, so any responsible employee who hears about it has an obligation to report to the EEO manager. So imagine the scenario where I, as employee, comes to you as another employee and say, I'm concerned, and you say, fill out the form. And I say, well, I don't know. Then it's on you, and I don't fill out the form. It's on you as a responsible employee to report to the EEO manager too. So that, I think, but there may be more to your comment, but I think that then starts to make sure that we don't, and it's very strongly, I think, a sentiment that we want to get across in the policy is that we should be very clear to all of our employees that just handing people the form does not fulfill your responsibility. If a student doesn't fill it out or is unable to fill it out, or an employee for that matter, we still have an obligation to move this forward and make sure it's investigated.
Absolutely, and so that is my point. Looking at letter B juxtaposed with letter C, to me as a reader who may not understand mandatory reporting, I may say, oh, they didn't give me a form, so I'm not going to take it forward. So possibly either combining B and C so that it's not a one or the other, it's a both. They're going to tell you whether they tell you or they give you a piece of paper, you need to take action. So just clarifying that, because C could be a response by someone who, either doesn't file in a timely manner or isn't aware of the process, isn't able to support the employee or the student.
Great point. And I think that was our intention, so we can make that clear, because I think that and this is going to be a very important point as we go to implement, is that I'm going to stress this again. I said it before, but this isn't only on the person who's the complainant to come forward. We all have a responsibility as city schools employees and and then there's an encouragement of the broader community to report, and that piece is going to be a very important part to make sure to emphasize.
Perfect. And then with the new federal regulation of shall, I would strongly advocate that we as a district say, that may, or so that we go above and beyond the federal. I just think that's the current administration and where they're going to land on these things is perhaps not where we want to necessarily hold as our minimum threshold.
Right, and so that's on the definition of sexual harassment. Is that where you're going there? So this is a little tricky. So what we need to do, because the federal regulations actually, you can't go above or below. This is one of those ones.
Oh, that was minimum threshold.
Well, so So in terms of the Title IX definition of sexual harassment, that needs to be pervasive, severe, with the or. But then we can, and that's why we made clear, as for students, student code of conduct, we can go beyond that, and we try to make that clear, but we can make it even clearer, and we can go beyond it as sex-based discrimination or workplace discrimination from an employee perspective. But it's just that the trick here is that there's one thing that's regulated by this Title IX piece, and then we go beyond it with other federal state protections or student code of conduct protections. So we're going beyond, but we need to not refer to it as Title IX protected sexual harassment. And so that was the nuance that we're trying to walk here. So we affirm this board and this community's want to go beyond without running afoul of the federal folks here.
Yeah. So just three more quick pieces. One, in the use of the language of complainant respondent and not imposing any disciplinary consequences while investigating. I understand, the motivation of protecting, but especially with children, you talked about employees being able to shift spaces. Are we able to take actions to protect children in the process while also protecting the respondent?
So I should say this is an area where I think that unfortunately the federal government had the college and university frame in mind, not the K-12 frame in mind. And I really do worry that the way in which we've long designed our student discipline regulations to have the sort of 10-day, right, and even shorter in Baltimore City commitment to have a hearing and a swift period and a consequence imposed. I mean, if you have, I am concerned about two third graders who have a sexual harassment incident between them. We would, prior to this regulation, have done an investigation, imposed a disciplinary consequence within a couple of days. I mean, in the most extreme, maybe it was extreme, maybe it was a day or two suspension, but there were probably also consequences that were worked out in the educational context. I'm thinking third graders. This, in theory, gives people rights that if you count it out, it's more than 20 or 30 days and to a disciplinary imposition. So I really worry about for the importance for third graders and I can go up of having a prompt and appropriate response as part of the school environment. This is going to complicate them, but so having said all that, there is this provision for an emergency removal that I think we will have to treat exactly like we did it, and we'll just invoke that proceeding, and that applies to both students and employees. And we want to make that clear, but we can make that even clearer. One thing I should also say here is, given everything else that's going on in our schools right now, we're going to make this process lots of support from my office. So there's so many steps in this that could trip up a principal because it's so different. So we're going to make sure that there's active engagement in investigating and supporting so that we don't run afoul and become the poster child for the first litigation under this new regulation. Yeah. If I have anything to do with it, at least.
I would rather be sued by a respondent than not take care of someone who perceives or, right, in the definitions has been a victim. Two last things on side 21 of your presentation. It's not a huge thing, but the way that it's laid out, it looks like the definitions are matching, like it's an A and B match, and they're not. And so when you share this at the public board meeting, you might want to just reformat your graph because it's looking like, agendered lines up with, so it looks like this is the definition from one policy to the next policy. Noted.
Apologies.
Oh, no, it's not. It's just, we don't want to get tripped up in public over something that you're very clear in right now. And then the last question is around dress code. You mentioned changes to dress code. Are we willing as a board, so this is probably more of a comment to my other colleagues, are we willing to make statements about graduation ceremony, traditional uniform? that are required to be women in white, men in blue, or required to be some other thing that is very historied. And how do we plan to handle that? Because Josh, you may not know this, Chief Sivan, but a number of our schools have a very long history of graduation where one gender dresses in one color and the other gender dresses in the other color, and there's no ifs, ands, or about it. They do allow people to pick where they are, but even just in that binary representation goes against the spirit and of this.
And if I might interject quickly, so in the existing language of JBB, it actually does say, this is on page 6, I believe, of the red line, dress codes for designated school events like dances, graduations, and other ceremonies shall be gender neutral. So that's existing language in there. The staff doesn't match that because that's geared to students. But if we wanted to make the staff one align more clearly, but that is existing language in JBB.
Right, and I know that it wasn't necessarily overly adhered to, so just pointing that out. That's all my questions, Mr. Chair. Thank you.
Thank you. Chair Chinio or Commissioner Robert McFadden?
If I may, Linda, and I'll defer back to you, but since we were on page 6 with number 4 in JBB, with athletics and physical ed, I would just urge us to include dance education also in that, because dance education is separate from physical education. Oftentimes we group them together and they're separate. And there are instances, when there are young people and they're dressing and things like that. So I would add that to JBB, to the policy, just that, that minor update. I have something else, but Linda, Commissioner Chinya, you're muted.
You go ahead and finish. I don't have a lot, so you go right ahead.
Thank you. So for ACB, in the regulation, I'm thinking about page 6, and also in the regulation for JBB on page 20, we talk about training specifically for the managers, for supervisors, and it outlines the time period when when they should be receiving the training, right? At least up to an hour. But we don't specify when the rest of our employees are trained. And I think that we should be clear about that and the duration of time. So are they being trained prior to the start of the school year? Is it the same amount of time that the managers are receiving? And it's the same thing in JBB for the students. And I know this could be going into a different policy perhaps, but when do our students become educated on this policy, on sex-based discrimination? And where would that fall in the regulation here, or would that fall in another policy somewhere else in curriculum? Just had that question.
My understanding is that in the this has fallen in the sex ed curriculum standards, at least statewide, but let us work on that as part of the work from now till first reader.
And Chief, it could be, thank you for that. And it could be something that we consider adding to our code of conduct, interjecting it somewhere there, because it is something that our young people take. This is just a thought. I know that you're going to look into it and check all of that, but just moving forward, a way that we could ensure that not only our young people, our younger people are introduced to this information, but also their parents and families. So yes, we have the policy and the guidelines for training for our staff and our employees, but also just consider how we educate. Yes, perhaps in sex ed, right, in health ed, But I think about our elementary school students who don't necessarily receive that instruction until they reach the secondary school age. So it's just a
And I
thought.
said sex ed, I meant health ed. Thanks for correcting me.
All good. But that's it for me, Dr. Chair.
And Chair Jania, did you want to jump in?
Yeah, the Commissioner McFadden just touched on the one that was really resonating most with me, and that was around the issue of training, because this is going to be very important. And my hope is that it's not, I mean, I'm just thinking back to the way we've been doing the training around abuse, child abuse, and generally it's all pushed into the very beginning of the year. It's sort of the mandatory kind of thing. My hope is that however this is occurring, that there's some way to consider ongoing, and some way to touch on it throughout the year. Both of these are just really, to me, crucial components of what we need to do for the safety of students and staff. And so a one-time sort of, check off the box, the training is just not going to work for this one. That the other things people have mentioned, but that was the key one that really, and again, for both staff as well as students.
I appreciate that, Linda. And with us now being in the virtual space with the ability to have online modules and things like that, I agree with you. This should be something that we consider just in general, the way that we do professional learning, and the ability to now blend what we do. I think that's a great point that you made. So it can happen more than once, and it can happen, outside of, the whole faculty's here, so we're going to give a training this way. We're just in a more innovative space where we can ensure that folks really understand the importance of this policy.
Yeah, thanks.
Mr. Chair, may I add one thing?
Sure.
Okay, so a space to look at this ongoing training and this ongoing really getting it penetrating in all schools would be to look at placing it with the wellness committees. So ensure, we already have a wellness policy that mandates a wellness committee at every school. Using that committee to sort of be a train the trainer model, to be the point people. They're already invested. Oftentimes, they're working with students in that way, and given the mental health aspects of our wellness policy, it might be a nice way to double down without having to add another layer of bureaucracy to a process.
And we also have, to that effect, but we can also look at aligning. We have the for a while we've had student bullying point of conducts in the school. So we've added to that Title IX and this piece, but I think that we can look at integrating with the wellness work.
And also, especially because so many of the wellness people are health and physical educators, so they're already well versed, or should be well versed in Title IX. So it may help disseminate accurate information.
Great. And so, Chief Sivan, I have a ton of questions, so I'm just going to rattle a bunch of them off, and then you kind of enter at some point, and maybe we can, if there's something that we need to come back to a little bit later, we could discuss. But there are two, I guess one of the, starting with ACB 2C, with the incorporation of the new language around or sexual assault and domestic violence is looking like. Wondering if there's a way to talk more specifically about intimate partner violence, or trying to get clear about domestic. Are we thinking just family, or are we talking about dating and relationships? And so one of the distinctions between the definition is that, for intimate partner violence, it actually, the CDC has past and prior. So I mean, current or prior partners. And so that could definitely impact whether or not something was coded as a sexual harassment or, domestic violence. So getting some clarity around that particular language would be helpful. And I'm going in no particular order. I just, one of the things that kept coming up for me is around compliance and sort of how we begin to track and monitor. And so it looked like your office would be doing the tracking and the monitoring for central office, but I wasn't clear around sort of who would be doing that, ensuring that the principals were doing what they were supposed to be doing. And so I didn't know if you would be doing that, or I would hope that it would just be getting done. And I'm not sure that process, because it wasn't clear there. I just want to make sure that the principals are, whether they're sending out their, they're responsible for the school, right? That resolving situations. So make sure they have the correct information, that they sent it out. And then I would love it if central office could at least aggregate that information to see if, that they got it, and then that they're actually implementing it.
Great, and the intent, just to interject there, the intent is that when it is a sex-based discrimination investigation, that if the principal is doing the investigation, it's still reported up to the EEO and Title IX office, so they're providing support, but also, to your point, tracking and monitoring. So, and we tried, I think there's still more work to do, but we tried to start to align the bullying, harassment, and intimidation student-on-student process and this process, because one of the things we found is that depending on which form you fill out, sometimes there's a different result. And what we want to move towards is a student should report activity, and we'll sort out on the back end how it's going to go forward, and make sure that we get the resources to have a result. And obviously, we want to be respectful of how a student wants to pursue that, but the key point here is that all these processes have to be aligned.
Yeah, thank you. And I think one of the areas that felt in my thinking was a little bit tricky, because I know that there are different thresholds for discrimination versus sort of what we would talk about, or sex-based discrimination versus sort of harassment, and with the inclusion of making sure that all three of those have to be, those new criteria have to be stated. What I didn't see in the harassment report that was given last year was any differentiation between any of these new priorities around sex, gender, et cetera. So even when we're aligning around monitoring, our compliance reports aren't even capturing what these categories of criteria are. And so, that's kind of one of the areas on my mind, to making sure that.
And I think that's an important point that we share. And so making sure that then our tracking aligns with those pieces is going to be an important part of this process.
Great, thank you for that. And so let's see. So I was hoping if and Chief Sivan, if there were ways to include examples in this as well, or maybe it's supplementary, but I think, or it goes into training or whatever, but I think there's some ways in which examples about what something is specifically around language or harassment that feels important, and particularly around this idea around using dead names, right? So if we have a person who's identifying as trans, or want to do a name change and that sort of thing, like what's the policy? Is a dead name considered a violation, using that intentionally, or does it have to be used once? Like, how do we begin to sort of give some real concrete examples about what this really means in practice? Because a person, a teacher or someone or student could keep doing and engaging in that, but if we don't have that written down in policy as an example, then we get stuck in it. We get in a situation where that person is being harmed, but we're not actually given an account for that. So I just kind of wanted to flag that. Yeah, did you want to respond?
Yeah, I think that's important to look at both in the policy and regulation, but also in training. And I smiled when you said that, because I think one of the challenges always with putting examples in is that sometimes when you put a list, it's the thing that we didn't think of that becomes the next incident. So we should, and I think there's a way to do this, make sure to give examples without making it in any way think that that's the only list of examples, and that's the sum total of them. And that's a really important legal trick that we want to guard against.
Absolutely. I just know that, especially when I think about trans specific circumstances, like we've seen as a form, these really specific either gender or identity-based forms of harassment that go unnoticed because they're not coded as harassment, even though we know they're causing harm to people. So I don't want to so I just want to be able to kind of get at some of that uniqueness without getting it lost in the sauce.
And I think that's great. And I think one thing just I'll mention, because I forgot to mention at the outset, is that while there was language in JBB that talked about sex-based stereotyping, we actually folded that into the definition of sex-based discrimination. And we also folded into the definition actions that may not have intent connected to them, but have a disparate impact that's unjustified by anything but. So that's we did some work to make the definition of sex-based discrimination more robust, with the idea that that gives opportunities for some behaviors that haven't been called out in the past to have ways for us to have accountability attached to them.
Great. And so I'll take a pause because I still have more questions, but I want to invite other commissioners, if they had additional questions that came up, to chime in as well.
I don't have a question, but I just want to add, as we're talking about training and a group that I didn't hear anybody say, but let's be certain that we include parents in this training that we are talking about, because I don't know why I didn't say it earlier, but.
Great. Awesome. So I did have a question. This is still on ACB, and I think it was on page 10, and it's about the EEO manager. And it says the question or the statement says something about timely, but it doesn't give a time. So I was just curious about what timely was, and if that was kind of some federal reason for using the word just timely versus actually giving it a concrete.
Right. We can. I think that's a good point. We can go through and put some more concrete timelines in places. There were a number of places where it was just how much more work we could do at that point on the existing. But we will definitely take that back as a desire to be concrete where we can on timelines for expectations.
Great, thank you so much.
I mean, there's always going to be the case where, as I said that, there's always going to be the case where law enforcement's involved, and so the timelines need to slow down. But I think that the point we can make is what's the norm, and then we can say in exceptional circumstances, but the norm is important.
Thanks. And so there were, in terms of, I think, sort of the threshold, because when we, so I've been around for a year, so when I saw some semblance of this presentation, not this presentation, but with some data, compliance data, it just said there were two examples of reports of sex-based discrimination or something like that. And so I know that's based on threshold and legality, but they did not report, and I mentioned earlier, some of the other forms of harassment. So I just kind of want to help people distinguish around sort of the difference between thresholds and the legal pieces versus us trying to do some real supportive affirmative work as well. And so just because it's doesn't meet the legal standard, I still want to know in a compliance report whether or not what type of form of harassment or bullying took place. And of course, that goes back to what I mentioned earlier, that we just didn't have it there before. And I also didn't see the form. And so maybe I missed it. If there's a way to actually see this, the ACB, the form, so I can see what it looks like?
Sure.
Okay, because then I want to know what types of questions are on there, and then making sure that they're linked up appropriately. And so.
And to that end, I mean, one of the things that I think was work that we've talked about, and it may be that we have there are different approaches to whether we want to have a specific form for sex-based discrimination or to have all discrimination claims on a common form, recognizing that sometimes things don't fit into neat boxes and there's multiple parts of it. So one of the pieces that welcome your all's reaction to, and we're discussing internally, is it better to have a lot of forms or more than one form for more particular behavior, or is it better to have a general form with a number of questions on it, which may make it easier for, I mean, a pro would be that it would make it easier for people to know there's a form when I'm experiencing behavior that I think is because of who I am, this is the form that I fill out, versus having to know as the complainant which form to fill. And again, pros and cons on each of those, but that's an important piece as we go forward to think about.
Yeah, and I know that there was some discussion around sort of the fact that the form was online. I mean, you had to download it and all of these complicated pieces. So I think that's, you know, great conversation to stay in. And I think I have a few more questions. Now moving to JBB, and because I think everybody else mentioned those. Mentioned that. It was again around tracking. Schools are responsible for remediating issues. Again, who's tracking? How do we make sure that everything is actually happening in a way that matters or gets captured? And I think one of the biggest things for me was with this process, and I think we talked a little bit about this, how do we take into account for differentials in power? And so if a student is reporting an incident with a teacher or a principal, and it's related to their sexual identity or gender identity, like the process that we have laid out would seem that they would be equal. So one, what does a youth-friendly sort of engagement or walk through this look like? And then two, like, how are we supporting a younger person navigating this process? And because I haven't seen it, so I don't know much about it, but I would love to be in discussion around this, because we know that there are power differentials that are at play at any given time, even during normal mediations or you know, those particular pieces.
Absolutely. And so one of the things that I'm thinking about in response to this is I'm thinking that a flow chart of walking through this may be helpful just as we go forward. I saw one district that did a flow chart, so we can work on having that both not just as for the part of the policy, but so people who want to file will understand what happens. And I think that the way that the Title IX coordinator is now set up, and then the Title IX coordinators at the school, are designed to be the people who support through the process. And that's why I think that one thing that's good, dare I say, about the new regulations is to say that there's a Title IX coordinator who supports the process, and then there's somebody who investigates it. So you're getting support, and then there's investigating. And I think that making sure that the support piece and the negotiation piece happens regardless is a really important part of trying to address those power differentials that are not just, I think, you know, can occur in any situation where there's sex-based discrimination, not just when positionally the two people are in different positions.
Great, thank you. And there was a piece around the student records. And so my question was, who can request the change? So if a parent is unsupportive, but the young person is very clear around that they need these records to be different, do we have a process to support them? And can they request that? And would that be honored if that it is in disagreement with what their parents might have to say? So
let's start with preferred name or chosen name first. So I think that our practice, and we're working on making sure that implementation is consistent with what we're saying, is that a student should be able to do that themselves and be honored in that, even if there's parent opposition. One of the things that we actually laid out in some guidance we issued, which I think we shared with the board, but if not, we can, around use of preferred or chosen name in virtual platforms, because we wanted to be very clear at the beginning of the school year that we were not using dead names to the point we were making before, and allowing students and making sure that it's not just the student themselves changing the name, but actually that the draw from Infinite Campus was our student recognition system is drawing based on the chosen name as opposed to the given name if a student prefers. But we wanted also to make sure that school staff, whether it's a counselor or the principal, somebody who has a relationship with a kid, is walking a student through the implications of that change, because in the virtual world, it may be even more impactful than in school, where a student can choose on their own to be called by a preferred name, even if they don't want their parent to know about that. When they're in virtual instruction and their parent might walk by the screen, we want to make sure that we talk through with the student the implications of that to them, and particularly work it through and be very attentive as we build a support model. And there's some language here more explicitly about a support model. So this moves beyond just compliance and to support how we're working with students to understand how they, what's the level of parent support, and then how to work this through. So the first time we're dealing with the issue of parent opposition is not at graduation. If there's parent opposition, we're trying to work with the student so they are getting support from school staff that they trust and have a relationship with in understanding and getting support, and recognizing if there's a real safety concern about a family member, that we're taking steps in that stage too. So that's on preferred or chosen name. On the official student record, that requires, and through some of work that I did a number of years ago, we got MSDE to open up the categories of documents that you could submit to change your official name. So it's not just the birth certificate or a court order, but it's also a statement from a doctor who's working with the student that the name needs to be changed. So that statement, I would assume in most circumstances, a student, especially a student under 18, would need a parent involved or a guardian involved to change an official court document. But there's a potential for, with a statement from a physician, or it's actually not just a physician, it's a medical practitioner, to move forward. And we are going to work to be clear about how to support students who are in that situation.
Great, thank you. And so I think like I'm out of like official questions. I think one of the things that came to my mind just broadly was, you know, how do we begin to sort of link, because I think we referenced JICKRA around that policy and the particularly around, I believe that was harassment and that sort of thing, and making sure that they are connected to make sure that we're connected. We're getting the types of synergy that we need across policy to make sure that our compliances reports are going to be consistent. So that was kind of just the other thought that was, because it was referenced in there. But then also thinking, just can't emphasize enough of how do we begin to move, not only making sure that we have our compliance pieces, legal pieces together, but then into the supportive domain as well. You know, Commissioner Hassan talked about wellness coordinators and so forth, and really kind of want to think about sort of robust ways and training and consistent development of our teachers, students, and staff, and in this case also parents, to really try to support all of our students in that way. And so I didn't know if any other commissioners had any other questions.
I'm good, thank you.
Great. Okay, and so we'll hear from Christian. We're going to open for public comment and hear from Kimberly Mooney.
Ms. Mooney? I see you. I don't hear you yet.
Can you hear me?
Yes, we can hear you. You have the normal 3 minutes.
Okay, thank you very much.
Thank you.
Hi, my name is Kimberly Mooney. I'm here to represent Glisson, Maryland, as I'm the board chair there, but I'm also an employee of city schools, so this means a lot to me. So policy JBB and and the staff one that corresponds are both very important. So I first want to thank you for having these policies and implementing them. But I would like to encourage a couple of revisions and improvements. Policy standard in JBB policy standard 3.A.3 states sex-based discrimination can be committed by any person of any sex against a person of the same or opposite sex. Opposite sex should be stricken, and this section should simply state that sex-based discrimination can be committed by any person of any sex against a person of any sex. Opposite sex erases intersex individuals, and it really isn't in line with the X designation on driver's licenses, for example. Policy standard 3.B.1 talks about use of names and pronouns, and 3.B.2 talks about dress codes. And with the dress code thing, I just wanted to echo what Commissioner James Hassan said, that although that it's in there, that the dress code should be gender neutral, that's often not the actual practice. So there really needs to be professional development for educators so that they know how to implement this policy. Policy standard 3.B.5 talks about student records. So looking at that one with the one about pronouns, it's a little bit confusing because it talks about student report cards, transcripts, and diplomas being the official ones that can only be changed by the official process that's described. So it's unclear for things like IEPs, 504s, things like that, which name, like the legal name, or whether the chosen name should be preferred or should be utilized. And if it is legal and possible, I think that we should encourage chosen names to be used everywhere. Under policy 3.B.5, it talks about the request process for name and gender change, but it says to contact the Office of Enrollment Choice and Transfers. However, there's no contact information right there for that office, which makes it a little difficult. So I would encourage that to be updated. Also, the formatting is really confusing right there. So if that could be updated, that would be really helpful. 3.B.3 talks about access to gender segregated facilities. And I just wonder how we ensure that gender neutral facilities are required to be built into new buildings. So a lot of this stuff has implications for other areas. And I just wonder how we make sure that this gets connected to all the right people to actually implement it. In the compliance section, under 5B, it talks about it says the CEO or designee will report training statistics and schedules for ongoing compliance review and so on. But it's been a year and 5 months since this policy has passed, and no training has happened either to facilitate school leaders and educators' understanding of the policy and terminology, or explain how to implement the policy. And I don't know of any updates in regarding to plans for that PD. So I think, one, the policy should specify how often updates have to be given regarding training. And if the board has the ability to set up a timeline for the training itself, I think that would really help with accountability. I know I'm probably toward the end of my time, just going to wrap it up, but I would just like to say the district really, in particular, especially in the online environment, needs to proactively seek students' preferred names and genders so they are not outed. That by itself could be a reason why students could disengage from online learning. And staff members are actually facing the same problem. And I do want to shout out Shauna Anthony in Human Capital. She's been instrumental in trying to address this. But data management software and training on the importance of handling this personal data properly would expedite and support those efforts. For staff, there is no procedure that I can see in ACB for staff members to request that their records be updated. And there's no training or notification process for students either, as one of the commissioners said earlier, for letting them know what their rights are and how to make the complaint. Expecting them to know how to navigate board docs is really not reasonable. And I know you said that sorry.
Oh, Kimberly, you're at time. And so if you have any like additional things, please email us for all of these pieces so that we can keep tracking and monitoring. And I think when, I emailed and I said, like, I think moving forward, it's going to be really important to, I think, keep having the conversations and keep bringing up these really specific ways in which this policy is achieving its goals or are not, and that we're all in the loop. And I definitely hear you on this piece around, it's been a year and some change, and we still haven't gotten the pieces that we need. And so I'm hoping that the momentum moving forward is going to begin to kind of shift that culture and that context into something that's more affirmative and supportive. So I definitely want to thank you for the commitment to the work and just, this has been a long road. And there's so much work that needs to be done. And, you definitely have my sort of my commitment to making sure that all of our students have the best possible educational outcomes as well. So I just want to thank you for your comments today, and send everything else to Christian and we'll make sure that. Okay, great. Awesome. Thank you. And so Commissioner, Chief Sivan, one of the things that kind of came to my mind was the, so when we're doing I think it might have actually gone out of my brain that quickly. Yeah. Okay, maybe it's gone. So
I was gonna stall for you by making one point that just
right.
on new construction, we've updated now, and I think there was a separate presentation, our ed specs, which is the standards for construction, to have gender neutral facilities as part of that. And that was one point that I just wanted to stress.
Awesome.
Is that a good stall?
It was a good stall, but it didn't come back. But I definitely wanted to just thinking about like this piece around cross-referencing and sort of, because this policy touches on so many different areas, to really think about how, as we saw in the last presentation, like how does each department actually start to implement this piece, and how do we track and we monitor it? Feels really, really important. And then I'm so glad that your office specifically is really being able to capture this work and hold it, so it can have a place to live, so we can also go back to someone to say, hey, where is this? And so are there any other questions from our commissioners?
All good over here, sir.
Awesome. So if we don't have any more questions, I think we are done. And so let me see. Christian, do you have any updates before I read off the upcoming meetings and the agenda items?
No, I don't, but thank you.
Awesome. So just a note. So I wanted to thank again Chief Sivan for giving this presentation and all the awesome work that's going on to really begin to shift and move LGBTQ inclusion and support services to the next level. Our next meeting is going to be on October the 20th at 3:30 p.m. It's a virtual meeting. There we'll be talking about policy board rules, JFF school activity fund. We'll be talking about JBEH, which is around legal representation. And then we'll be revisiting some procedures and appeals and hearings through BLA, BLB, and BLC. Always, if you'd like to sign up for public comment, please do so in advance. And it says advanced sign up is permitted only beginning at 9 a.m. on the Thursday before the meeting until 5 p.m. on Monday before the meeting date. Individuals who or groups interested in providing comments to the committee may sign up in 3 ways. You can contact our office, which is 443-984-2000. You can visit the board office. Well, probably can't do that now. And then you can email our board office, which is schoolboard@bcps.k12.md.us. And so with that being said, if there are no other comments, I will close this meeting at 4:45 p.m. And thank you all for coming. Awesome, thank you.